Hello there. Welcome to Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. In this video, we shall talk about the institution of Lok Adalat. The institution of Lok Adalat in India, as the very name suggests, means people's court where justice is dispensed summarily without too much emphasis on legal technicalities. It is a forum where disputes and cases pending in the court of law or at pre-litigation stage are settled or compromised amicably. It draws from the panchayat system of justice, where panchas or village elders helped villagers resolve their disputes. Lok Adalats have been given statutory status under the Legal Services Authorities Act 1987 and have proved to be a very effective alternative to litigation. There is no restriction on the power of Lok Adalat to pass an award based on the compromise arrived at between parties in a case referred by a court under Section 138 of the Negotiable Instrument Act. And by virtue of the deeming provision, it has to be treated as a decree capable of execution by a civil court. Lok Adalats have been very successful in settlement of motor accident claim cases, matrimonial and family disputes, labor disputes, and disputes relating to public services such as telephone, electricity, and bank recovery cases. The advantages of Lok Adalats are that they work in the spirit of compromise and understanding, which makes both parties feel satisfied. They deliver inexpensive and fast justice and allow any person to move Lok Adalat by an application on a plain paper or by using the format available with the legal services authorities. They help in reducing the workload of other courts, which enables the courts to look into more serious matters. This results in reduction of delays in higher courts. The advent of Legal Services Authorities Act 1987 gave a statutory status to Lok Adalats, pursuant to the constitutional mandate in Article 39A of the Constitution of India. It contains various provisions for settlement of disputes through Lok Adalat. This act mandates constitution of legal services authorities to provide free and competent legal services to the weaker sections of the society and to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. It also mandates organization of Lok Adalats to ensure that the operation of the legal system promotes justice on the basis of equal opportunity. The parties are not allowed to be represented by lawyers and are encouraged to interact with the judge, who helps in arriving at amicable settlement. No fee is paid by the parties. Strict rules of civil procedural court and evidence is not applied. Decision is by informal sitting and is binding on the parties. No appeal lies against the order of the Lok Adalat. Lok Adalats have jurisdiction to determine and to arrive at a compromise or settlement between the parties to a dispute in respect of any case pending before or any matter which is falling within the jurisdiction of and is not brought before any court for which the Lok Adalat is organized. The Lok Adalat can compromise and settle even criminal cases, which are compoundable under the relevant laws. Lok Adalats have the competence to deal with a number of cases, like compoundable civil, revenue, and criminal cases, motor accident compensation claims cases, partition claims, damages cases, matrimonial and family disputes, mutation of lands cases, land patta cases, bonded labor cases, land acquisition disputes, banks' unpaid loan cases, arrears of retirement benefit cases, family court cases, and cases which are not sub judice. One issue which raises its head often is the finality of the award of the Lok Adalat. During the Lok Adalat, the parties agree to abide by the decision of the judge at the Lok Adalat. However, it is often seen that later the same order is challenged on several grounds. In one of its recent decisions, the Supreme Court has once again laid to rest all such doubts. In unequivocal terms, the court has held that award of the Lok Adalat is as good as the decree of a court, and therefore the courts have all the powers in relation thereto as it has in relation to a decree passed by itself. The award passed by the Lok Adalat is the decision of the court itself, though arrived at by the simpler method of conciliation instead of the process of arguments in court. The most important factor to be considered while deciding the cases at the Lok Adalat is the consent of both the parties. It cannot be forced on any party that the matter has to be decided by the Lok Adalat. However, once the parties agree that the matter has to be decided by the Lok Adalat, then any party cannot walk away from the decision of the Lok Adalat. In several instances, the Supreme Court has held that if there was no consent, the award of the Lok Adalat is not executable, and also if the parties fail to agree to get the dispute resolved through the Lok Adalat, the regular litigation process remains open for the contesting parties. The Supreme Court has also held that compromise implies some element of accommodation on each side. It is not apt to describe it as total surrender. A compromise is always bilateral and means mutual adjustment. Settlement is termination of legal proceedings by mutual consent. If no compromise or settlement is or could be arrived at, no order can be passed by the Lok Adalat. Let us now have a look at the levels and composition of Lok Adalats. At the state level, the member secretary of the State Legal Services Authority organizing the Lok Adalat constitutes benches of the Lok Adalat. Each bench comprises of a sitting or retired judge of the High Court or a sitting or retired judicial officer, a member from the legal profession, and a social worker engaged in the upliftment of the weaker sections and interested in the implementation of legal services schemes or programs. At High Court level, the Secretary of the High Court Legal Services Committee constitutes benches of the Lok Adalat, each bench comprising of a sitting or retired judge of the High Court, a member from the legal profession, and a social worker engaged in the upliftment of the weaker sections and interested in the implementation of legal services schemes or programs. At the district level, the Secretary of the District Legal Services Authority organizing the Lok Adalat would constitute benches of the Lok Adalat, each bench comprising of a sitting or retired judicial officer, a member from the legal profession, and a social worker engaged in the upliftment of the weaker sections and interested in the implementation of legal services schemes or programs, or a person engaged in paralegal activities of the area, preferably a woman. At the Taluk level, the Secretary of the Taluk Legal Services Committee organizing the Lok Adalat constitutes benches of the Lok Adalat, each bench comprising of a sitting or retired judicial officer and a member from the legal profession, a social worker engaged in the upliftment of the weaker sections and interested in the implementation of legal services schemes or programs, or a person engaged in paralegal activities of the area, preferably a woman. The other type of Lok Adalat is the Permanent Lok Adalat, organized under Section 22B of the Legal Services Authorities Act 1987. Permanent Lok Adalats have been set up as permanent bodies with a chairman and two members for providing compulsory pre-litigative mechanism for conciliation and settlement of cases relating to public utility services. Here, even if the parties fail to reach a settlement, the Permanent Lok Adalat gets jurisdiction to decide the dispute, provided the dispute does not relate to any offence. Further, the award of the Permanent Lok Adalat is final and binding on all the parties. The jurisdiction of the Permanent Lok Adalats is up to rupees 10 lakhs. The Lok Adalat may conduct the proceedings in such a manner as it considers appropriate, taking into account the circumstances of the case and wishes of the parties, like requests to hear oral statements, speedy settlements of dispute, etc. Mobile Lok Adalats are also organized in various parts of the country, which travel from one location to another to resolve disputes in order to facilitate the resolution of disputes through this mechanism. In conclusion, we may say that Lok Adalats have become an integral part of the Indian legal system and have become avenues for access to justice for the poor and downtrodden. They have bridged the gap to legal aid and are one more step towards the concept of good governance. Well, that's all from me in this video. This video is based on the information freely available on the internet. I express my gratitude to all the media and legal websites for the information carried by them. The intention of this video is to prepare candidates for answering examination questions on the subject. Do like this video and do subscribe to my channel now so that you do not miss out on my previous or future videos. Till later then, cheerio.